वेलकम टू लर्न शॉर्ट एंड टाइपिंग विद विकास सर। स्टूडेंट्स, हम आपके लिए एक सीरीज चलाने जा रहे हैं जो आपके लीगल मैटर की डिक्टेशन होगी, जो सुप्रीम कोर्ट एंड हरियाणा हाई कोर्ट के लिए इम्पोर्टेंट रहेगा। आपके किसी भी आपका कोई भी आपका कोर्ट हो सभी के लिए इम्पोर्टेंट रहने वाला है। ये आपके 700 वर्ड आएंगे, 80 वर्ड पर मिनट की स्पीड आएगी। इसमें आपकी 100 की स्पीड और 120 की स्पीड इसमें आपको मेंशन की जाएगी। सो आप इसको ध्यान से सुने और इसको आप अच्छे से लिखें और टाइप करें। सो बी रेडी, स्टार्ट। Whether an offence under section 138 of the Negotiable Instruments Act can be compounded after the confirmation of the conviction passed by the magistrate court, by the appellate court and high court in revision. Whether an order passed by the High Court in a criminal revision petition confirming the conviction can be nullified by the High Court in a petition filed under Section 482 of CRPC, noticing subsequent compromise of the case by the contesting parties. What is the effect of the non-obstante clause notwithstanding anything contained in the Code of Criminal Procedure in Section 147 of the NL Act? These are the main questions to be considered in this case. It was held by the learned single judge of this court that offence under Section 138 can criminal 14 C 540/2007 can be compounded even after confirmation of the conviction by the High Court in revision, and considering the subsequent facts of compromise, necessary relief can be given in a petition under Section 482 of the CRPC by this court. Another learned single judge of this court expressed doubt after the correctness of the above decision and thus referred this matter to the division bench. Stop. Before answering the reference, we shall consider the facts of this case. A check issued by the accused for an amount of rupees 25,000 was dishonored for insufficiency of funds, and he faced charges under Section 138 of the NI Act. After trial, he was convicted by the magistrate court and sentenced to undergo simple imprisonment for 1 year with a fine of rupees 5,000. His conviction was confirmed. Stop. In appeal, but sentence was modified and he was sentenced to undergo simple imprisonment for 3 months. In the revision application, this court by order dated 23/3/2007 confirmed the conviction, but sentence was modified to imprisonment till rising of the court and to buy a compensation of rupees 25,000 under section 357 oblique 3 of CRPC. Stop. Thereafter, this petition was filed in May 2007 under Section 482 of the Code of Criminal Procedure by the accused petitioner for the following reliefs: to accept the compounding application jointly filed by the parties and to return the fine amount of rupees 5,000 already deposited before the magistrate court. Stop. In the joint petition by the parties accused and complainant, prayer is as follows. Stop. In the above circumstances and in the interest of justice, this honorable court may be pleased to permit the petitioners to compound the offence and acquit the first petitioner. Stop. Counsel for the petitioner relied on the decision of Sabu George within bracket supra bracket close for allowing the petition. Stop. But learned single judge was of the opinion that order of conviction became final by the order of the High Court, and hence he cannot be acquitted in a petition under Section 482 of CRPC and doubted the correctness of the above decision with the following observation. The legal effect of allowing this petition by invoking the inherent power of this court would be to efface the conviction entered and sentenced passed by this court in criminal revision petition number 667/2000, which in the normal course could have been interfered with only by the Supreme Court in appropriate proceedings. After from the fact that the consequence which is sought to be avoided by the accused is not one following from the proceedings of an inferior court, the course now sought to be resorted to appears to be impracticable in the light of the decision of the apex court. Moreover, a reading of subsections 4 within bracket A, 4 within bracket B, 5 and 6 of section 320 CRPC would indicate that compounding can be had only in the pending proceedings and with the permission or consent, as the case may be, of the court, even if the offence is one compoundable without the permission of the court. In the case of offences falling under subsection of section 320 CRPC, the very fact that those offences can be compounded only with the permission of the court would suggest that some proceedings should be pending before the court when the request to compound the offences is made and entertained. Stop. A proceeding which has culminated in a final order cannot, in my view, be reviewed by filing a compounding petition. Stop. In Sabu George's case, this court has considered two petitions. Stop. In one case, after confirmation of conviction by this court in revision petition number 1540/2007. Criminal miscellaneous application number 8626/2006 was filed by compounding the case. Later criminal miscellaneous case number 259/2007 was also filed under section 482 of the CRPC for compounding the case. In the next case, after confirmation of the conviction under section 138 of the Negotiable Instruments Act, writ petition civil number 34540/2006 was filed to compound the case. Stop.